Hi, my name is Dorothy, and I am a juror in the AU Bright Smile Dental case number 4. AU Dental has been accused of breaching patient confidentiality by labeling AIDS patients' folders with a red label and the word AIDS on the outside of the folder in plain view of the patients and the staff. After carefully listening to the evidence presented by the plaintiff and the defendant, I have decided to rule in favor of the plaintiff for the following reasons. 1. The labeling of the medical records were done unprofessionally. A patient diagnosis should never be exposed to the public. There were other ways to flag the folder, such as color coordination and encrypting. A patient's record should be filed, stored, and restricted from public access. There is a breach in the patient's informational privacy. The patient information privacy is controlling who has access to the personal information. And the word AIDS on the outside of the folder takes away all privacy rights. The defendant plainly states that the medical records were flagged with a red label and the word AIDS on the outside of the folder, which is evidence of breach of confidentiality and failure to protect the patient's health information, which is required to be protected under the Health Insurance Portability and Accountability Act, which is HIPAA. The Federal Privacy Act of 1974 states that no agency shall disclose any record which is contained in a system of records by any means of communication to any person or to another agency except pursuant to a written request by or with the prior written consent of the individual of whom the record pertains. There was no written consent to share the patient's information. The defendant also stated that the patient was involved in a number of rape cases, and the police was requesting information on the patient. The police does not have the right to request medical information without a court order. And the court order they must have a court order to release medical information. There's no mention of a court order for AU Dental to release any information. Also, it is not the doctor's responsibility to expose to a third party that a person has AIDS. The doctor can advise the patient. The doctor can advise his patient to contact their sexual partner or partners. For example, a case heard in the New South Wales Supreme Court in 1999, the court held that a medical practitioner owed a duty of care to sexual partners of a patient with AIDS. If the patient's results were positive, then the doctor could not inform the partners directly, but there was an obligation to counsel the patient to inform their sexual partner or partners of their HIV status, and to instruct the patient regarding the patient's own statutory responsibility to inform partners or partners before engaging in sexual intercourse with them. Therefore, considering the evidence presented before me, I have ruled in favor of the plaintiff. Thank you.